You're welcome. Mr. Rodriguez. That'll be item number 7, AB 1959. Assault on an EMT.
Good morning.
Good morning.
Thank you, Mr. Chair and members.
Whenever you're ready, begin.
Thank you. Good morning, Mr. Chair and members. AB 1959 equalizes the penalties for assault against emergency medical technicians to that of firefighters and peace officers. California law recognizes the unique risks and dangers that law enforcement and firefighters face in the workplace and has deemed that assaulting either in the line of duty is especially reprehensible. However, EMTs and paramedics do not benefit from the same protections under current law. EMTs are 14 times more likely to be violently injured on the job than that of firefighters that they work alongside. Our EMTs and paramedics risk their own lives and well-being in the service of others as they respond to crisis with their law enforcement and firefighter counterparts. With over 30 years of experience as myself as an EMT, I have seen firsthand the violent situations that EMTs encounter on a day-to-day basis. We must recognize that EMT safety is in the workplace is that the equal of peace officers and firefighters. Here with me today is Chris McKelly of the California Ambulance Association and Sean Hensel from American Medical Response to testify on my behalf.
Thank you.
Good morning, Mr. Chair and members. Sean Henschel here in support on behalf of American Medical Response, California's largest provider of 911 emergency medical services. We respectfully ask for your aye vote. We want to thank and applaud the author for his efforts on this issue.
Mr. Chair, Chris McKelly on behalf of the California Ambulance Association. We certainly appreciate our law enforcement brethren and certainly don't equate the daily threats to their lives in the same manner, but EMTs and paramedics often, what's been reported to us most often is in the context of domestic disputes. As first responders, we face some very serious challenges. In some rural areas, we are not just the first responders, but the sole responders. So we appreciate the Assemblyman's efforts in this regard and urge your support for the bill.
Yes.
John Lovell, Association for Los Angeles Deputy Sheriffs, California Association of Code Enforcement Officers, California College and University Police Chiefs Association, California Narcotic Officers Association, Los Angeles County Professional Peace Officers Association, Los Angeles Police Protective League, and Riverside Sheriffs Association, all in strong support.
Thank you. Are there any witnesses in favor of the bill?
Asha Harris on behalf of the California State Sheriff's Association in support.
Marla Marshall on behalf of Sheriff Bill Gore and the San Diego County Sheriff's Department in support.
Thank you. Is there any witnesses in opposition? Good morning.
Good morning, Mr. Chair and members. Khalif Osterguy on behalf of the California Public Defenders Association in respectful opposition to this bill. Under existing law, assault with a deadly weapon, if charged as a felony, is a strike and carries a potential punishment of up to 4 years. If the charged individual has a previous criminal record for similar conduct, his maximum prison sentence increases exponentially, 13 years for the second offense and life for the third offense. Although the punishment for this conduct is already enormous, the proposed bill seeks to increase both the minimum and maximum prison sentence for individuals engaged in this conduct. Imposing increasingly harsh punishments for unlawful conduct is an age-old but failed response to otherwise legitimate public safety concerns. Unfortunately, as California's current incarceration crisis and high recidivism rate shows, legislative focus on increased prison sentences instead of rehabilitation is costly, cruel, and also ineffective. AB 1959, while well-intentioned, presents no evidence that will result in a corresponding reduction in the conduct cited, but does guarantee additional cost to the state, an increased number of Californians in prison, and more Californians spending more time warehoused in prisons rather than engaging in rehabilitative processes. Because of the justice policies calling for ever-increasing amounts of prison time are ineffective, expensive, and significant step backwards on the road to criminal justice reform. We urge you to vote no on this legislation.
Thank you.
Micah Doctoroff on behalf of the ACLU of California, also in respectful opposition to the bill. While AB 1859 appears to seek to provide greater protection for emergency medical technicians by increasing penalties, research has shown that more severe sentences do not actually enhance public safety, and that certainty of punishment has a far greater deterrent effect than the severity of the punishment itself. While there are increased punishments for assaults against peace officers and firefighters, the increase follows a clear line that the legislature has drawn time and again, treating serious crimes committed against peace officers and firefighters differently from other categories of crime, given that they expose themselves to risk for the benefit of public safety at large, without diminishing in any way the critical duties performed by emergency medical technicians. We do not believe that the elevated penalties should be extended, particularly when there is no indication that the elevated penalties would offer greater protection. And therefore, we respectfully oppose the bill.
Thank you. Are there any other witnesses in opposition? Okay. Are there any questions from committee members? Mr. Quirk.
Yes, for reasons as just stated by the opposition, I won't be able to support your bill. Again, I have tremendous respect, but there is no evidence that increasing the penalty would actually stop people from doing this, and then we do still have a prison overcrowding problem. So again, I do respect you and the profession that you've been a part of for many years.
Any other questions or statements? Okay, and so I'm a little conflicted too, and I'm not going to make a recommendation. And where my conflict is, one, with the opponents and the overcrowding, but also I have a unique perspective of being an emergency preparedness coordinator during the civil unrest. And for Los Angeles, it was the first time we ever had a major riot of that kind since the 60s. And I remember firefighters, EMTs rushing to those areas, and they were shot at. And luckily, no one was seriously injured. But I do remember in the Emergency Operations Center having serious discussions about how do we protect firefighters and how do we protect EMTs and paramedics and people who are going out there to save lives. And it was a big conflict. You know, do you arm them with heavy weaponry as they go out to save people, or what do you do? And there were some discussions even about martial law and increasing some penalties for people who did that during that time. Obviously, nothing happened during that time, but it just struck me that people who were out there going to save, we didn't have a mechanism to really protect them. And yes, that was back in '92, and the number of times, thank God, the number of times that EMTs are shot or killed in the line of duty in those kind of incidents are low or nil. I mean, and so the numbers. And so I'm going back and forth, and so I'm going to stay off. I'm not making a recommendation today, but like Mr. Quirk, obviously we have a whole lot of respect for you, Mr. Rodriguez, and we understand what you're trying to do. But again, I'm conflicted on this one. Yeah. Ready to call the roll? Do we have no, been moved and seconded?
No.
It's been moved and seconded.
AB 1959, the motion is due past to appropriations. Jones Sawyer?
Not voting.
Jones Sawyer not voting. Melendez? Aye. Melendez, aye. Lackey? Aye. Lackey, aye. Lopez? Lowe? Aye. Lowe, aye. Quirk?
No.
Quirk, no. Santiago?
On call. Okay. And now Ms. Campos. AB 1762, item number 2. So, Ms. Campos, whenever you're ready to begin.
Thank you for your patience, and good morning, Chair and members. I will be accepting the committee's suggested amendments for AB 1762, which would allow victims of human trafficking to vacate their criminal record for nonviolence convictions. Human trafficking is an extensive problem within the United States, especially in California, with its significant immigration population and the world's 9th largest economy, is one of the nation's top 4 destination states for trafficking. As you will later hear from my witness, who will be able to explain this in detail from life experiences, many human trafficking victims are forced to commit a wide range of crimes. Some of these include prostitution, selling drugs, theft, and fraud-related crimes. Due to their traffickers, they tend to be fearful to say that they are being trafficked and that they are being forced to create these crimes for someone else. And so that when they are caught and brought before a court, they do not, they tend to take the fault for a crime that they not willingly wanted to commit. And this bill then creates a pathway for them to never be able to truly get out of a cycle. And once they find their way through a path that alleviates them from human trafficking, their record continues to follow them. Currently, over 19 states permit human trafficking victims to vacate or expunge their record of convictions for crimes committed as direct result of human trafficking. However, California has only passed a narrow law permitting sex trafficking victims to vacate convictions for prostitution upon proof by clear and convicting evidence. AB 1762 would be available for all nonviolent crimes committed by victims as a direct result of human trafficking, not just prostitution. This bill is needed. There are 19 states that currently allow for this process, New York being one of the top states that actually has taken the lead on this. I think this is an important bill that needs to go forward. I'm looking for my colleagues on the other aisle to be supportive of this as well, and hopefully we can all work together to stop human trafficking in California. It's unfortunate that we are one of the top states that has human trafficking. But as I was sitting across the table with law enforcement and experts within this jurisdiction, what they said to me, which should have been the obvious thing, is that California has so much wealth. And so whether it's the wealth of individuals that feel that they have the ability to do this, or it's the wealth that people feel that they can come and start a business because in some crazy way this is a business for some people and their livelihood, but they should not be human trafficking in the state of California, and we should not be harming individuals and them to be able to have their ability to be able to lead productive lives without a criminal record that they did not do on their own will. So with that, I will turn it over to my witnesses. Thank you.
Thank you. Hello, my name is Stephanie Richard. I'm the Policy and Legal Services Director at the Coalition to Abolish Slavery and Trafficking, otherwise known as CAST. I stand here today and ask for you to support AB 1762, vacating convictions for human trafficking survivors as amended. I stand here today on behalf of Keisha. I stand here today on behalf of Marty. I stand here today on behalf of Alex and all human trafficking survivors that CAST has served who have not been able to have their criminal convictions expunged because the current California expungement law is inadequate to assist them. This includes AB 1585, enacted in 2014, which was supposed to provide trafficking victims with a new way to expunge convictions. CAST serves clients daily with 10 to 20 convictions, sometimes 30. I've had a client with 200 convictions. Human trafficking is a unique crime in that as part of their criminal exploitation, they're forced to commit crimes that benefit only their trafficker, and yet often because of fear of their trafficker or fear of the very system designed to protect them, they instead are convicted of crimes. This criminal record haunts them the rest of their life and creates barriers to employment, housing, and other benefits. As one survivor puts it, even though I'm free from my trafficker, I still feel the invisible bonds of slavery because of my criminal convictions. California can do better to put a system in place that recognizes this unique type of exploitation that trafficking victims face and helps them mitigate these consequences in a fair and a just system, balancing their needs for justice along with the system's need for justice as well. First, we know that based on the ground experience working with thousands of victims that having a special standard for vacation of prostitution or solicitation convictions is not enough for trafficking survivors, as they are arrested for such varied crimes as drug possession, sales, trespassing, fraud, to name a few. And if you can only convict 5 out of 10 records, you're facing the same problems and the same barriers. I want to stress that under this bill, just because you're a trafficking victim does not mean that you can just simply vacate any crime. What this gives you the opportunity to do is, in a strict judicial system and process, is make the argument that the particular crime was directly related to the trafficking victimization, and for that reason it should be vacated. If the court does not agree, then the record will remain. Second, I would like to stress that this bill only deals with victims after they've been convicted of a criminal offense. So it in no way encourages perpetrators to use victims to commit more crimes, as the system remains exactly the same, except that a victim can vacate a crime for an additional reason, that they were victims of that very crime they were convicted of. In fact, Cass believes that this additional protection for victims could lead to additional evidence for our prosecution partners so that they can go after the real perpetrators. Third, I'd like to highlight that the additional protection of not having to complete the terms of probation and pay fines and fees is an appropriate additional protections for victims of trafficking. Cass has had to tell many clients to come back in 2 years, in 3 years, and it's then that we can help you with your expungements. Trafficking survivors cannot wait that long to find work and homes. That is why they end up being re-trafficked or re-exploited. Additionally, I'd like to stress that these measures do protect other crime victims' rights. If the system has made a mistake and convicted one victim wrongly instead of the true perpetrator, the trafficker, that mistake must be corrected, and that victim should not have to face the additional fines and fees created by her own exploitation. Okay. Ashley, sitting next to me, paid over $2,500 in fees to have her expungement. For those reasons, I would like to ask for your support and turn it over to Ashley.
Okay, Ashley, you have 2 minutes.
2 minutes. Okay, I'm going to go as fast as I possibly can. Good morning. Hello, my name is Ashley Dickerson. I am a survivor advocate that works closely with Cass. I want to take the opportunity to thank you guys today for having us here and in support of AB 1762. I stand here today as a voice for the voiceless and a face for victims and survivors all over, as once I was a victim myself. This bill has the ability to change the way victims recover from their traumatic situations. It offers a small resolution to a piece that has been taken from them. The bill recognizes us victims and survivors as people. It gives us opportunity to move forward and not be chained to our victimization. I was 14 when my victimization began. I ran away from home. I was trafficked in Riverside for a few years and then in other counties in Los Angeles. I was trafficked for 14 years of my life. When I was able to get out of the life, it was very hard. I had no education, no job training, and no job skills to get a job. The criminal record that I had was another reason that I had so many issues. I have 12 convictions in Los Angeles County, 3 in San Bernardino County, and 4 in Orange County. Getting out of the life was very hard. I was not able to get a job due to my record. I was not able to pay my fines due to not having a job, and that's a hard thing for us as survivors and as victims. I have had 11 of my 12 convictions in Los Angeles County expunged. I had to deal with community care licensing and many issues surrounding my convictions. It's hard to let people know that you have a past. honest. When people are reading you off of a piece of paper, off of black and white, looking at you as a prostitute or whatever your convictions are, it's hard for us to move forward from that. It's hard for us to get a job. It's hard for us to get further education. I myself have been very lucky to be working with CAST. They have helped me in so many different ways. It's amazing. This bill will eliminate the issues for our victims and survivors who are struggling with similar situations. It will help them build their futures and grow. They will be able to reach their full potential without judgment or rejection due to their past. Human trafficking victims do not have a choice in their victimization, but this will give them an opportunity, a chance, and a life. Thank you.
Thank you. Are there any?
Move the bill.
I'll second it. Are there any witnesses in support? Name and organization.
Good morning. My name is Claire Lipschultz. I'm with the National Council of Jewish Women, and I urge the committee's support for the bill.
Thank you.
Hello, my name is Sarah Linder with National Association of Social Workers, California chapter, and I urge your support for AB 1762.
Thank you.
Khalif Osagai on behalf of the California Public Defenders Association in strong support.
Thank you.
Micah Doctoroff on behalf of the ACLU of California in support.
Jim Lindberg on behalf of the Friends Committee on Legislation of California. We're in support.
Thank you. Are there any witnesses in opposition?
Good morning.
Good morning.
It is unfortunate that I find myself sitting here in opposition of the bill. I don't disagree with the Assembly members' intentions or with those of CAST, the sponsors. In fact, we've been working with CAST on some of the other bills to try to find a compromise that both protects public safety and protects our children. The one word that both the Assembly member and Stephanie Richards used was that victims of trafficking are forced to commit crimes, and that is true. However, this legislation doesn't say that. It says that if somebody is a victim of human trafficking and as a direct result of that, that they can have their criminal history either set aside or expunged. The truth is we have young people who are under a trafficker that are committing crimes that don't really have anything to do with that. A simple example is somebody goes into a restaurant and eats and then refuses to pay a bill and says, well, I'm hungry, I'm being trafficked, so I shouldn't have to pay. And that's a simple example. But I'll give you one that we saw the other day, and that is that we had 3 young women who are 15, 16, and 17 who went into a store, each took a shopping cart, filled it with merchandise, pushed their way out, knocked over the clerk, hurt him, left him on the ground, got into a car with all of the merchandise that they had just stolen, and they led the police on a 100-mile-an-hour chase through the freeways of the Bay Area. When they were brought into the Juvenile Justice Center, they asked, or they both, all 3 declared, I'm a victim of human trafficking, and I want to go to girls' court, which is our specialty court for dealing with trafficked children. The bill, those girls committed those crimes not because they were being trafficked. They committed the crimes because they committed the crimes. And so part of what this bill does is that it allows somebody to just file a petition, an affidavit. And if the court believes the affidavit alone, that could be enough. But in fact, if all 3 of those young women could have just, as they did, make their declaration, and that would be enough. But there's no way to challenge the declaration because they're not being cross-examined and we're not being able to go further than the facts. And so while I do support the concept of this, and I believe that we could come to language that creates a fair process, not just for victims of crimes that are being committed, but to be more specific about how we're going to identify those people who are being trafficked and are forced to commit crimes versus somebody who's committing crimes and also being trafficked. The other part of, and I know that there's a compromised place. I do believe there's a compromised place because in the end we want to protect our children. We want to protect people who are being trafficked. And there's one other section in this bill that simply removes penalties for engaging in commercial sex for minors, which essentially is legalizing commercial sex for minors. And what I feel, and after 20 years of working in this field with victims of trafficking and some other young women and boys who are not the victim of human trafficking, but nevertheless being sexually exploited by being involved in the commercial sex. And if we don't link them into services through some process, and we're trying to work on that with other legislation, that we are basically driving them back into being the forgotten children that we've worked so hard to bring them, give them a face and give them a voice.
Okay, thank you. Yes, sir.
Good morning. My name is Morgan Geyer. I'm a Deputy District Attorney for Sacramento County. I'll just have a few brief points, and I respectfully oppose this bill as well. Procedurally, the way it occurs, the standard is a direct result of their victimization of human trafficking and provides no guidance for that. These crimes that are allowed through this vacatur proceedings allow for crimes such as voluntary manslaughter, residential burglary, crimes that may not be associated with human trafficking. And the only mechanism by which these petitions can be vetted are through an affidavit process, not an evidentiary hearing where additional evidence can be presented that can rebut this presumption that someone is a victim of human trafficking, and that is quite problematic. Second, if we terminate those proceedings on, particularly our children, as Ms. O'Malley just mentioned, we lose our status on them. We lose our jurisdiction over them to require them to participate in the programs that they won't otherwise participate in. And after having done this job for almost 17 years, if we don't do that, these young boys and girls will run and we won't be able to help them. So because of the sort of ambiguous process in this bill, I will urge the committee to vote no. Thank you.
Thank you. Are there any witnesses in opposition?
Sean Hoffman with the California District Attorneys Association, also in opposition.
Thank you. Are there any other witnesses in opposition? Are there any committee members that have? Mr. Quirk. So,
with due respect to the district attorneys who've just spoken, particularly Alameda County DA, I believe that the bill as amended in committee satisfies your concerns. In particular, the burden of proof is clear and convincing evidence that the crimes were committed because of human trafficking. Further, there has to be a conviction first, and then they can go to this process. So I really think that if your concerns were not met, I would be concerned as well. But I do think they're met by this revised version of the bill in committee, and therefore I urge my fellow members to vote aye on this.
Okay. Are there any other questions? Mr. Lackey.
Yeah, I'm really struggling with this one. Clearly, human trafficking is a scourge that we all are trying to remedy and bring some reasonable solutions to. But I think the opposition is clearly a supporter of trying to bring that same kind of remedy to the table. And I think they bring some reasonable concerns to the table, and especially that, and I know my fellow committee member feels that the nexus between being a victim of human trafficking and these criminal allegations, or actually crimes that are committed, is satisfied. But I think that that's a blurry part of, but it's such a critical component. And I think it's the nuance that we have to wrestle with as to the difference between committing the crimes because of this condition or using it as an explanation for other problems. And so I'm wrestling with this, and I don't know if I'll be able to support. I'll probably take a non-voting to see what happens with you working with the opposition.
Thank you. And your closing statement?
I hear the concerns of the opposition. And listening to the testimony, I am not privy to sit in a room where the three young women committed the crime in the store, but I would imagine that if somebody asked them to blankly fill a shopping cart and try to leave a facility in broad daylight, there could be an underline of saying, I need help, or wanting to get caught. Because there's a cry out there for another reason to get out of the life. Because as I've had the opportunity to deal with the domestic violence issues as I was a council member and being here for the past 16 years, there's always another underline on why and I'm going to say women, because I've worked with women more than men. And we as policymakers, it is up to us to continue to create pathways that are respectful and give them a process that they can have to be able to expunge their records. And I would leave it at that and respectfully ask for your aye vote.
Okay. Thank you. The chair is recommending an aye vote, really based on the author's willingness to make some changes to ensure that the incident that the DA rightfully brought to this committee's attention talked about. I mean, we asked the same thing here on the committee about whether or not individuals could use this, or I even said even gang members could use this as a vehicle to increase their nefarious crimes, knowing that people underage would not be treated harshly, or in this case, have their crimes expunged. So I know on heinous crimes, this doesn't fall underneath this, and so that obviously is a great comfort. And the fact that you're willing to ensure that within, I guess, 30 days, the prosecutorial agency has an opportunity to come, and state and local have an opportunity to make their claim. Like she said, that these individuals who went in with the shopping cart, they weren't part of that, that there's a checks and balance. I mean, that's really, really important, and that there's a checks and balance. And I feel comfortable that, Ms. Campos, and you as the author, that you're going to make sure that it is as tight and as stringent as possible. And so that's why I'm recommending an aye vote.
Mr. Chair, I will commit that to you.
It probably moved in second. Madam Secretary, call the roll.
AB 1762, the motion is due pass as amended to appropriations. Jones Sawyer?
Aye.
Jones Sawyer, aye. Melendez? Melendez, no. Lackey? Lackey not voting. Lopez? Lowe? Quirk?
Aye.
Quirk, aye. Santiago?
It's on call.
Thank you.
We need two more.